The topic now is penalties. O magiging sa criminal law na to, no? Penalties magiging general substance din. Anyway, penalty is defined as the suffering that is inflicted by the state for the transgression of a law. The concept of penalty in its general sense signifies pain. Penalty, pain. Especially considered in the juridical sphere. It means suffering undergone because of the action of human society by one who commits a crime. So when there is a crime, there should be a penalty for corresponding to that crime. Different juridical conditions of penalty. It must be productive of suffering without, however, affecting the integrity of the human personality. Must be commensurate with the offense. Different crimes must be punished with different penalties. Must be personal. No one should be punished for the crime of another. Must be legal. It is the consequence of a judgment according to law. Must be certain. No one may escape its effects. Must be equal for all. Must be correctional. These are the juridical conditions of penalty according to the classical school on which the code is mainly based. No? Juries justifying penalty: prevention, self-defense, reformation, exemplarity, justice. In prevention, the state must punish the criminal to prevent or suppress the danger to the state arising from the criminal acts of the offender. In self-defense, the state has a right to punish the criminal as a measure of self-defense so as to protect society from the threat and wrong inflicted by the criminal. Reformation, the object of punishment in criminal cases is to correct and reform the offender. Exemplarity, the criminal is punished to serve as an example to deter others from committing crimes. Justice, that crime must be punished by the state as an act of retributive justice, a vindication of absolute right and moral law violated by the criminal. So those are the theories justifying penalties. Okay, the penalty under this code has threefold purpose. Retribution or expiation, the penalty is commensurate with the gravity of the offense under this code, under the revised penal code. Second, correction or reformation as shown by the rules which regulate the execution of the penalties consisting in deprivation of liberty. And third, social defense, shown by its inflexible severity to recidivists and habitual delinquents. Balo mga word nga sa recidivists ug habitual delinquents permanently lang nakasala. Criminal offense wag yun, no? The Constitution directs that excessive fine shall not be imposed nor cruel and unusual punishment inflicted. The punishment is cruel and unusual when it is so disproportionate to the offense committed as to shock the moral sense of all reasonable men as to what is right and proper under the circumstances. The example given is are those inflicted at the whipping post or in pillory, burning at the stake, breaking on the wheel, and the like. Whipping post, budal-budalan ka sa likod, no? Pillory, burning at the stake, talagang tusukan ka ng kahoy sa mudugan, and then sunugon, and breaking on the wheel, sa manapot, sa ana. Kapuson ang imuang kamot, tiil, bilangkad ka, tapos imong kamot, magdupa, gigapos na kanang upat, tiil kamot, duha ka kamot, o duha ka tiil, gapos. And then, so while gigapos ka, katong gagapos sa imo, katong PC nga gihikot, asa gihikot na tumoy, kaya PC, nay sakyanan dito. Mo nang wheel, nay sakyanan. So, sakyanan, pagpato na siya, pagawas, no? Birahon ka sa sakyanan. Instead na ato sa imo, pagawas na siya. So, siyempre, mabinat yun ka, no? Mo na siya ang breaking on the wheel. Nahilag kung sa'yo mabugto sa imo, ang imubang tiil o imubang kamot. So those are the example of the very cruel and excessive penalties. No? So let's go to the provision. Article 21, penalties that may be imposed. No felony shall be punishable by any penalty not prescribed by law prior to its commission. So there's no law when there's no crime that punishes it. Well. Mali. There's no crime when there's no law punishes it. Mo na ang caveat at mo na ang karang principle dira. Again, there's no crime when there's no law that punishes it. So Article 21 simplified that particular principle. There's no crime when there's no law punishing it. No felony shall be punishable by any penalty not prescribed by law prior to its commission. So this article is general in its provisions and in effect prohibits the government from punishing any person for any felony with any penalty which has not been prescribed by law. Wala siya prescribed sa law, wala penalty, then illegal siya punishable. It has no application to any of the provisions of revised penal code for the reason that for every felony defined in the code, a penalty has been prescribed. Reason for the provision: an act or omission cannot be punished by the state if at the time it was committed, there was no law prohibiting it, because a law cannot be rationally obeyed unless it is first shown, and a man cannot be expected to obey an order that has not been given. Let's go to Article 22, retroactive effect of penal laws. O, retroactive effect ha. Maricol niyo atong discussion ng retroactivity. It will retroact, the effect of penal laws will retroact only, it is allowed to be retroact, no, na retroactive effect. But prospective yun ang penal laws actually. Kung kano sa siya enact ang penal law provision, diha na siya magsugod up to the future. Dili siya pwede i-effect sa atras, pabalik, no? Like karon sa mataron, October 14 siya gi-enact ang balaod, dili siya pwede i-effect dito sa October 1 na commission. Na-commit siya ito sa October 1, October 14 gi-enact ang balaod, dili siya pwede retroact dito. Not unless, no? Let's read Article 22. Retroactive effect of penal laws. Penal laws shall have a retroactive effect insofar as they favor the person guilty of a felony. Yan. Who is not a habitual criminal, as this term is defined in Rule 5 of Article 62 of this Code. Although at the time of the publication of such laws, a final sentence has been pronounced and the convict is serving the same. So it will retroact to the commission of the crime when doing so would benefit the accused. No? For example, it will reduce the penal law being promulgated will reduce the punishment of the criminal, will reduce the sentence, will reduce the gravity, will, if you can recall, will simplify the procedure, not necessarily complicating the procedure. I-complicate ang procedure, dili na siya pwede retroactive effect. But if it will simplify the procedure, then no, like that. If it will complicate the procedure, it will have a retroactive effect. You know? Nga naman kung complicate ang procedure, because when the penal law is enacted and that becomes the procedure for proving the case of the accused will be complicated, it will be more difficult, naturally it will benefit the accused, no? Pwede siya i-retroact actually, no? It will benefit the accused. So, kaya lisod naman siya i-prove. Kaya na-complicate na yung procedure. So, take note of that. Article 22, retroactive effect only when the same will benefit the accused. This provision clearly has no direct application to the provisions of the revised penal code. Its application to the revised penal code can only be invoked where some former or subsequent law is under consideration. It must necessarily relate to penal laws existing prior to the revised penal code, in which the penalty was less severe than those of the code, or to laws enacted subsequent to the revised penal code, in which the penalty is more favorable to the accused. It is not believed, therefore, that the legislature, in enacting Article 10 of the revised penal code, intended to provide that Article 22 should not be applicable to special laws. Article 23, effect of pardon by the offended party. So, we talk about pardon, ginapasaylo, no? So, kinsa ang nagapardon dire? Ang pardon by the offended party, meaning, kung kinsa to gibuhatan nimo crime, mo to dapat mo pardon, no? Mo na ang sabot dira. So, if you commit thievery against that particular woman, siya dapat amo pardon sa imuha. If you commit physical injury against that particular person, siya dapat amo pardon. So, what is the effect if the offended party or the victim will pardon the accused? A pardon by the offended party does not extinguish criminal action except as provided in Article 344 of this code. But civil liability with regard to the interest of the injured party is extinguished by express waiver. So, dili siya automatic nga ma-extinguish ang criminal action kung ma-pardon ang offended party, except as provided in Article 344. So, even if the injured party already pardoned the offender, the fiscal can still prosecute the offender. Such pardon by the offended party is not even a ground for the dismissal of the complaint or information. The reason is that the crime committed is an offense against the state. In criminal cases, the intervention of the aggrieved parties is limited to being witnesses for the prosecution. So, okay na siya nga tenet, no? Okay na siya nga principle. That there's no, even if i-pardon sa offended party, but the accused can still be tried, can still be prosecuted. Pero, in practicality, if the offended party pardoned the accused and there's no more other witness that the prosecution could have in order to prosecute the accused, then might as well be that the case be dismissed, no? Na-dismiss na gyapon kaya wala na may witness. So that's the effect actually. Iyan ang nangyayari actually doon sa mga court cases natin ngayon, no? Even if the case is so severe, homicide, murder, but for as long as there is no more witness to testify in court to prove that the murder and homicide is really committed, there's no use. The case could be dismissed. And this happens so when eventually the accused and the offended party have come into settlement. No, already, ana man gina. Na-damage man ko, bayaran ko nimo. Kung bayaran ako, di na ako mo testify. Ana yan usually ang ginabuhat na agreement nila dito. So, the fiscal or the prosecutor have no other option except to cause the dismissal of the case because he has no more witness to present in order to prove his case. Ayun ang nangyari doon. So, although, ideally, even if the offended party pardoned the accused, the state can still prosecute the accused, independent of the offended party. That is, if there are other witnesses that the prosecution can present in order to prove the case. Pero kung wala na talaga. Hindi na niya pwede ipadayon ang kaso, i-dismiss na lang nga. Compromise that does not extinguish criminal liability. What is compromise? Compromise is settlement of the case even before the case is filed. It's settlement by the parties, even when the case is ongoing, and even after the case has been decided, the party can still compromise. But when the criminal liability is being prosecuted, can the parties compromise, extinguish criminal liability? It says here that it does not, no? It is well settled that criminal liability for estafa is not affected by compromise, for it is a public offense which must be prosecuted and punished by the government on its own motion, even though complete reparation should have been made of the damage suffered by the offended party. There may be a compromise upon the civil liability arising from an offense, but such compromise shall not extinguish the public action for the imposition of the legal penalty. A contract stipulating for the renunciation of the right to prosecute an offense or waiving the criminal liability is void. Take note, void na siya. The consideration or subject matter is illegal. Come to think of it, it may be stated that way. So, ideally, if you settle your civil aspect, the criminal aspect can still proceed because if you have agreement as to the dismissal of the criminal aspect, that agreement is void. Given, no? Given na siya. But then again, as I have told you a while ago, what can the prosecution prove when he has no more witness to present, no? To prove the case. Wala na siya ma-present, no? Kaya ang na-compromise naman, wala na gani. I had a case na na-settle na po sa court, no? Akusado is charged with killing his girlfriend after raping her, no? Rape with homicide dito siya. Ang pagpatay niya kay siguro sa hitabo ato, giunsan niya to. Gibunalan niya bato ang ulo sa victim, ang uyab after niya gipahimuslan pagka-drug siguro, no. Anyway, moto na yung tabo ni abot ang mga ginikanan, nag-trial gikaso, tapos abot ang ginikanan, naging-istorya to akong kliyente sa ila, gibaya mga 150,000 siguro to ang ginikanan. Wala na na-testify ang ginikanan. Eventually the case has been dismissed. Abot asa na to ang kliyente, more guilty ito ang kliyente ba, but I cannot defend him to charge him na ipapriso siya. I cannot defend him and have him charged at the same time. Kapag mo depensa gani ka akusado, imo gyud siyang depensahan kisudak sa dili. Not necessarily because you condone, but because they have rights also. The accused have rights also that must be protected. Dito mo come in ang mga lawyer to protect the rights of the accused. A contract stipulating for the renunciation of the right to prosecute an offense or waiving the criminal liability is void. The consideration or subject matter is illegal, except as provided in Article 344 of this Code. The offended party in the crimes of adultery and concubinates, cannot institute criminal prosecution if he shall have consented or pardoned the offenders. Kanalang mga crime, adultery and concubinates, that's Article 344. The pardon here may be implied as continued inaction of the offended party after learning of the offense. The second paragraph of Article 344 requires also that both offenders must be pardoned by the offended party. In the crimes of seduction, abduction, rape, or acts of lasciviousness, there shall be no criminal prosecution if the offender has been expressly pardoned by the offended party or her parents, grandparents, or guardian, as the case may be. The pardon here must be expressed. So take note of these cases that pardon could exculpate the criminal liability of the accused. Kaning mga cases adultery, concubinates. Adultery is a crime committed by a woman against the husband. Concubinates is a crime committed by the husband against the wife. Ano siya ang distinction between the two. Seduction, i-mention dali abduction, rape, or acts of lasciviousness. Acts of lasciviousness, kanining mga binastos, God, mga hikapan ka, tapos mo react ka kada hikapan, alagad. So kung dili ka gusto nga hikapon, ayun na, palayo ka kay para dili ka mahikapan. Otherwise, kung nahikapan ka na, pwede ka mag-file og kaso nga acts of lasciviousness. I had a case. I don't know if nakuha na ninyo na wala pa ako na istorya rin sa inyo I defended the accused in the crime of rape. So, gidefend na ko siya in the crime of rape. And I was able to believe the narration of the accused that he did not rape the girl, actually. Siya nag-rape sa girl. I even visited the house where the alleged rape happened. Dito dapit sa may Turil man to. Dito na sa banyo. Ang banyo, perting guota. Tapos gi-rape to dito. Kung kayo banyo, ganang pila ka tayo. Isa lang, igula ka mang CR dito. Dito na gi-rape. Sa narration sa babae ko sa affidavit niya, gihigda. Dahil siya, may mahigdaan dito. Maglisod, magpahigda. So, agyot, baray ka ng believable jud kayo ang narration sa accused. So, di man ako na mahimo attorney, ano ba? But then again, even if he told me that he was innocent of the crime of rape, the parents of the accused talked to the victim and the parents also, and they settled the case. Nabayaran siya kanama 8,000 pesos may itong gibayad. Yat gibisitahan nyo na ito akusado sa prisuhan nga, tapos iingon siya nga iyang mamang papa kitambangan daw siya, bayaran lang ito kan girl para ma-dismiss ang kaso. Eventually na-dismiss ang kaso actually. So dugay na to ang kaso, no? Na-dismiss. Salamat siya, attorney, ang gawas na yun ko. Dugay na, mga several years later, nakita na ko ang akusado. Akong kliyente. Dito sa court. Nung sa mga dere, kaso lagi, attorney. Kung sa may kaso nimo, wala diri sa kwan, RTC man tong rape niya sa una. O wala diri sa RTC, attorney. Asa imo kwan, sa imo kaso karon? Nasa Municipal Trial Court in cities. So, lower court na siya sa RTC. Kung sa may kaso nimo, yun siya, acts of lasciviousness lagi, attorney. Acts of lasciviousness daw, no? So binastos, pasabot. Could be that guilty yun siya, dapat kung i-trial sa atong rape, guilty yun siya kay tinakpan po siya acts of lasciviousness. So kanjot ka ng dukirok yun siya na tao yun ito nga kliyente na. Anyway, so that was a long time ago. Story at experience ani. But then again, because we were talking here of seduction, abduction, rape, or acts of lasciviousness, that's why I was able to tell you my experience about the case. Article 24, measures of prevention of safety which are not considered penalties. The following shall not be considered as penalties. Kaya paminawan ninyo the arrest and temporary detention of accused persons as well as their detention by reason of insanity or imbecility or illness requiring their confinement in a hospital. So, kipreso ka because of temporary detention because nakasala ka. Kanang ipreso ka, nakasala ka para ibistay mong kaso, presuza ka unless maka-bail ban ka. But then again, since nagparayan pa yung kaso, wala pa kay penalty diya. Temporary detention na siya, preventive detention para in case ipatawag ka sa korte, papadala ka na yun dito sa korte. Kaysa naman wala kang i-detain, basig di pa ka mato dito sa korte, di mo parayan mong kaso. Second, it shall not be considered penalty when the commitment of a minor with the commitment of the minor to any of the institutions mentioned in Article 80 and for the purposes of specified therein. Ang rehabilitation niya i-commit siya dito for rehabilitation. It's not penalty. Suspension from the employment or public office during the trial or in order to institute proceedings. This is actually called preventive suspension, no? Kung kasagaran naghatag sa order ani ombudsman, ang kasagaran po sa kaso ng suspension is involving a public officer. Fines and other corrective measures which in the exercise of their administrative or disciplinary powers, superior officials may impose upon their subordinates. Deprivation of rights and the reparation which the civil law may establish in penal form. Yun yung hindi siya penalty Penal form siya pero gideprive kag rights, reparation which the civil law may establish in penal form. Why are they not considered penalties? They are not penalties because they are not imposed as a result of judicial proceedings. Those mentioned in paragraph numbers 1, 3, and 4 are merely preventive measures before conviction of offenders. The commitment of a minor mentioned in paragraph 2 is not a penalty because it is not imposed by the court in a judgment of conviction. The imposition of the sentence in such case is suspended. Example of deprivation of rights established in penal form by the civil laws is illustrated in the case of parents who are deprived of their parental authority if found guilty of the crime of corruption of their minor children in accordance with Article 332 of the Civil Code. Classification of penalties, Article 25. Penalties which may be imposed, the penalties which may be imposed according to this code under different classes are those included in the following. So, scale, principal penalties, capital punishment, death, afflictive penalties, reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, prison mayor, muna siya afflicted penalties correctional penalties, prison correctional, arresto mayor, suspension, dischero. Light penalties, arresto minor, public censure. Penalties common to the three preceding classes, fine and ban to keep the peace. Accessory penalties, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, suspension from public office, the right to vote and be voted for, the profession or calling, civil interdiction, indemnification, forfeiture or confiscation of instruments and proceeds of offense, payment of cost. Mano siya mga accessory penalties. Accessory penalties because there is a main penalty for this, no? There is a main penalty which is imprisonment. So, there the main penalty which is imprisonment plus kanima penalty dere na yung mga provisions sa balaod nga a specific crime could be meted with such penalty with accessory penalties. Like, for example, kaning civil interdiction. What is this civil interdiction, by the way? Kaya indemnification bayad man siya. And civil interdiction, anybody who has idea about what a civil interdiction is? Who can discuss what a civil interdiction is? Civil interdiction. Actually, you cannot enter into contract. Mura kang kanang disqualified to enter into contract because when you are suffering from civil interdiction, You are actually civilly dead. Civilly dead. Dili ka ka-enter into contract. Mo na sa contract ko, sa obligations and contracts man nga lesson, this person suffering from civil interdiction, dili na siya ka-enter into contract. Bisag unsa agreement. And he is being stripped of his parental authority over his children. He is also being stripped of his spousal authority over his wife or husband. So, mala siya. Ang iyang mga properties nga daghan kayo, di na siya ka-manage ana. Strip of his management rights. Yan yung civil interdiction. When can civil interdiction be suffered by the criminal being punished? A civil interdiction is an accessory penalty when the person is convicted of the crime with punishment of 12 years and 1 day of imprisonment to death. Pataas ng pataas, 12, basta minimum niya 12 years and 1 day to death. Nana siya kakibat nga civil interdiction. Okay? Ang sa death, pwede na, wala na kay death naman. Basta sa pamanan ng civil interdiction niyo, patay ka naman, no? Pero basta payon dito sa taas, gikan sa 12 years and 1 day nga imprisonment, di man niya, up to, well, reclusion perpetua, nanaon lang na to. Up to that, reclusion perpetua, 30 years na. So wala kay rights nga mo manage yung property because of suffering of civil interdiction. Kano sa po ni mawala ng civil interdiction nga accessory penalty. Wala na po na siya mawala kung ma-serve na nimo ang principal penalty. Say 12 years sa imang 13 years sa imang penalty. Na-serve na nimo na siya, tanggal na po ng imang civil interdiction. See? Mana siya ang bot-pasabot sa accessory penalties. They cannot exist without the presence of the main or principal penalties. Life imprisonment should be denominated reclusion perpetua since the technical term is the penalty that carries with it the imposition of the accessory penalties. Penalty of life imprisonment or cadena perpetua imposed by the trial court is an erroneous designation. The correct term is reclusion perpetua. The penalty of cadena perpetua was abolished by the revised Penal Code. Kaya na siyang cadena perpetua, reclusion perpetua na siya. Reclusion perpetua is not the same as life imprisonment. Why? As the revised Penal Code does not prescribe the penalty of life imprisonment for any of the felonies defined therein, the penalty being invariably imposed for serious offenses penalized not by the revised Penal Code but by special laws. So reclusion perpetua entails imprisonment for at least 30 years, after which the convict becomes eligible for pardon. It also carries with it accessory penalties, namely perpetual special disqualification, etc., including civil interdiction. It is not the same as life imprisonment, which, for one thing, it does not carry with it any accessory penalty, and for another, does not appear to have any definite extent or duration. Sa life imprisonment, wala definite extent. Take note, pinaka-central nga distinction is that sa reclusion perpetua, it is stated in the revised Penal Code, while life imprisonment is in other special laws. What are the classifications of penalties? It classifies into principal penalties, those expressly imposed by the courts in the judgment of conviction, accessory penalties, those that are deemed included in the imposition of the principal penalties. The principal penalties may be classified into according to their divisibility, divisible and indivisible penalties. Indivisible penalties are those which have no fixed duration. The indivisible penalties are death, reclusion perpetua, perpetual absolute or special disqualification, public censure. Wala na siya mga fixed duration Divisible penalties are those that have fixed duration and are divisible into 3 periods. So, classification of penalties according to subject matter: corporal, death; deprivation of freedom, reclusion, prison, aristo; restriction of freedom, dischero; deprivation of rights, disqualification and suspension; and pecuniary, fine, kwarta ni siya, ikuhaon sa imuha. Classification of penalties according to their gravity: capital, afflictive, correctional, light. This classification corresponds to the classification of the felonies in Article 9 into grave, least grave, and light. Grave, least grave, and light dito sa Article 9 lang. Public censure is a penalty. Censure being a penalty is not proper in acquittal. In a criminal case, there's only one issue: whether the accused is guilty or not guilty. If he is found guilty, the court acquires jurisdiction to impose a penalty. If he is found not guilty, no court has the power to mete out punishment. A finding of guilt must precede the punishment. Article 26, fine. With afflictive, correctional, or light penalty. So, fine is payment of money. May mga provision sa balaod nga nag-impose og fine lang or imprisonment or both fine and imprisonment. A fine, whether imposed as a single or as an alternative penalty, shall be considered an afflictive penalty if it exceeds 6,000 pesos. A correctional penalty if it does not exceed 6,000 pesos but is not less than 200 pesos, and a light penalty if it be less than 200 pesos. Pero amended na nga mga amount kaning 200 pesos karon for 40,000 pesos na ni. O na imo siyang i-concatenate, imo siyang i-extrapolate di ay. So could be i-divide ni mo ning 200,000 at 200 pesos to 600. Pila ka 200 pesos ang 60 no? Pila ka 200 pesos ang 6,000. That would be 200. 5 times 6, that's 30. 200 pesos. Multiply mo with 30 ang 6,000. So, multiply mo 30 ang 6,000, mo na siyang amount. Wala akong extrapolation but wala takagit naman amendatory law aning sa stand. I will tell you the amendatory law. I will pre-show it maybe next meeting kung sa to mga amendatory law that changes the amount of money fine actually. But ang pinaka-less diha ang 200 pesos dahil mo na siyang 40,000 pesos. Penalties cannot be imposed in alternative. The Court of First Instance of Quezon City found Alejandro Mercahidijas guilty of violation of RA number 145 and sentenced him to pay a fine of 1,000 pesos or to suffer an imprisonment of 2 years and to pay the cost. Held, the law does not permit any court to impose a sentence in the alternative. Its duty being to indicate the penalty imposed definitely and positively. May fine na gyud, may imprisonment na gyud. Pero ang balaod mo gud ingon, a fine or imprisonment or both fine and imprisonment at the discretion of the court. So mo ang choices. So ang court kung na specific law na ingon fine of 6,000 pesos or imprisonment of 6 months or both fine and imprisonment at the discretion of the court. So tulo ang choices sa court karon. I-fine niya og 6,000 pesos or i-imprison niya for 6 months or both impose niya ang judgment na fine plus imprisonment. O na siya. Dili po yung alternative mayon sa fine or imprisonment. Yung papili ang akusado doon siya. Of course, kung dili ka pa priso, fine na lang akong bayaran, no? Lahat ng bail, ang bail, man to, kanang, para na dili na ka mapriso while the case is ongoing. Piyansa man ang bail. But of course, kung mag-bail ka, kanang kung kwarta nga imong gi-bail, pag ma-found guilty na ka niya, ang judgment is fine, pwede ito gamiton ng bail. Pwede ito i-apply ang bail di mo, nga put up di mo ito, mabayad di mo sa fine. Kung ang bail di mo is 4,000 pesos, ay mong fine is 6,000 pesos, duwag na lang ang 2,000 para mabayaran mo ang fine. So you see the difference? Okay, so fine, afflictive is over 6,000 pesos, correctional 2,000 to 6,000, light penalty less than 2,000. Ban to keep the peace. So sa man yung ban to keep the peace? Kanibang na yung mga order, na yung mga judgment in certain cases na like dischero na yung mga kakibat ng accessory penalty ban to keep the peace, put up siya ban para lang balikan niya nga mo pan siya kanang mura siya bail ban actually, but this is not a bail ban kay kani siya penalty naman niya. Ang bail ban is for temporary liberty man to, pero ban to keep the peace na ini siya penalty na ganoon siya. In fact, they are being classified as afflictive, correctional, and light penalty. Afflictive when it is over 6,000 pesos. Correctional when it is 200 to 6,000. Light penalty when it is less than 200.